Welcome to the Law Key podcast, where you can listen and review case digests and get practical tips on how to survive law school in the Philippines. Studying law can be very challenging, especially for working students, but with the right tools, the right habits, and the right support group, we can surely survive it. This is Kim, your host, and I hope you enjoy and learn something from this episode. Here we go. Hi, so for today's episode, we will be discussing about the case of Susan Nictao Carino versus Susan Yi Carino with GR number 132529, decided on February 2, 2001. So this is a case focusing more on the persons and family relations. So let's start. So the issue for resolution, the case at bar, hinges on the validity of the two marriages contracted by the deceased SPO for Santiago S. Carino, whose death benefits is now the subject of the controversy between the two Susans whom he married. So the facts of the case are: during the lifetime of the late SPO for Santiago S. Carino, he actually contracted two marriages. The first one was on June 20, 1961 with petitioner Susan Nictao Carino, wherein he got two children. And then the second one was on November 10, 1992 with Susan Yi Carino, whom he had no children in their almost 10 years of cohabitation, starting way back in 1982. Now, in 1988, SPO for Santiago S. Carino became ill and bedridden due to diabetes complicated by pulmonary tuberculosis. Then he passed away on November 23, 1992 under the care of Susan Yi, who actually spent for his medical and burial expenses. So both petitioner and respondent filed claims for monetary benefits. So Susan Nictao was able to collect a total of 146 from as death benefit, while Susan Yi received 21,000 from GSIS burial and SSS burial benefit. Now, on December 14, 1993, Susan Yi filed the instant case for collection of the sum of money against Susan Nictao. So he contended to be that Nictao, Susan, would be ordered to return to her at least one half of the 160,000 pesos that she received. So Susan Yi admitted that her marriage to the deceased took place during the subsistence of and without first obtaining a judicial declaration of nullity of the marriage between petitioner and the deceased. She, however, claimed that she had no knowledge of the previous marriage and that she only became aware of it at the funeral of the deceased, where she met petitioner, who introduced herself as the wife of the deceased. So to bolster her action for collection of the sum of money, she said that, Susan Yi contended that the marriage of Nictao and Carino was void ab initio because the same was solemnized without the required marriage license. So she presented the marriage certificate of the deceased and the petitioner, which bears no marriage license. And then the second is a certification dated on March 9, 1994 from the local registrar of San Juan Metro Manila, which reads that the office certified that it has no record of marriage license of the spouses Santiago Carino and Susan Nictao. Whether or not the marriages contracted by Santiago Carino during his lifetime are valid, and whether or not both the petitioners and respondent are entitled to the death benefit of Santiago Carino. Now, the Supreme Court said that under Article 40 of the Civil Code, the absolute nullity of a previous marriage may be invoked for purposes of remarriage on the basis solely of a final judgment declaring such marriage void, meaning where the absolute nullity of a previous marriage is sought to be invoked for purposes of contracting a second marriage, the sole basis acceptable in law for said projected marriage to free from legal infirmity is a final judgment declaring that the previous marriage is void. However, for purposes other than remarriage, no judicial action is necessary to declare a marriage an absolute nullity. For other purposes, such as but not limited to the determination of heirship, legitimacy, or illegitimacy of a child, settlement of state, dissolution of property regime, and other, the court may pass upon the validity of marriage even after the death of the parties thereto, and even in a suit not directly instituted to question the validity of said marriage. So, for the first issue, which is whether or not the marriages contracted by Santiago during his lifetime are valid. So let's first take a look at the first marriage. So under the Civil Code, which was the law enforced when the marriage of petitioner Susan Icdao and the deceased was solemnized in 1969, a valid marriage license is a requisite of marriage, and the absence thereof, subject to certain exceptions, renders the marriage ab initio. Case at bar, there is no question that the marriage of petitioner and the deceased does not fall within the marriages that would exempt them from getting the license requirement. So a marriage license therefore was indispensable to the validity of their marriage. So this was proven through the evidence given by Susan Lee that there was really no marriage license in the marriage certificate of both Nicdao and Carino. Thus, the Supreme Court said that the said marriage is void ab initio. Such being the case, the presumed validity of the marriage of petitioner and the deceased has been sufficiently overcome. It then became the burden of petitioner to prove that their marriage is valid and that they secured the required marriage licenses. Again, the Supreme Court said that the marriage between Susan Icdao and Santiago Carino is void ab initio. However, they also mentioned that there has to be a final judgment to declare that it is void ab initio before Santiago contracted his second marriage with Susan Lee. So the Supreme Court said that it does not follow from the foregoing discussion, however, that since the marriage of petitioner and the deceased is declared void ab initio, the death benefits under scrutiny would now be awarded to respondent Susan Lee. To reiterate, under Article 40 of the Civil Code, or the Family Code rather, for purposes of remarriage, there must first be a prior judicial declaration of the nullity of a previous marriage, because before a party can enter into a second marriage. Otherwise, the second marriage would also be void. Accordingly, the declaration in the instant case of nullity of the previous marriage of the deceased and petitioner Susan Icdao does not validate the second marriage of the deceased with respondent Susan Lee. That is because the said marriage with Susan Lee was contracted without first obtaining a judicial decree declaring that the marriage of Susan Icdao and Carino was void ab initio. So in short, the marriage of respondent Lee and the deceased is likewise void ab initio. So the two marriages, according to the Supreme Court, was declared void ab initio. Now, with the second issue, that is whether or not both of the spouses of Carino are entitled to the death benefits of the deceased. According to the Supreme Court, considering that the two marriages are void ab initio, the applicable property regime would not be absolute community or conjugal partnership of property, but rather it would be governed by the provisions of Article 147 and 148 of the Family Code on property regime of unions without marriage. So under Article 148 of the Family Code, it refers to the property regime of bigamous marriage, adulterous relationships in a state of concubine, relationships where both man and woman are married to other persons. It states that the properties acquired by the parties through their actual joint contribution shall belong to the co-ownership. Wages and salaries earned by each property belong to him or her exclusively. Then 2, contributions in the form of care of the home, children, and household, or spiritual or moral inspiration are excluded in its regime. So, considering that the marriage of respondent Susan Yi and the deceased is a bigamous marriage because it was solemnized during the subsistence of the previous marriage, Article 148 is therefore applicable to her case. Now, the disputed 146,000 from MBAE is clearly an incentive and benefits from governmental agencies earned by the deceased as a police officer, and unless Susan Yi presents proof to the contrary, it could not be said that she contributed money, property, or industry in the acquisitions of these monetary benefits. Hence, they are not owned in common by respondent and the deceased, but belong to the deceased alone, and respondent has no right whatsoever to claim the same. By intestate succession, the said death benefits of the deceased shall pass to his legal heirs, and respondent, not being the legal wife of the deceased, is not one of them. So, as to the property regime of petitioner Susan Nicdao and the deceased, Article 147 of the Family Code governs. So, Article 147 reads that when a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without benefit of marriage or under a void marriage, their wages and salary shall be owned by them in equal shares, and the property acquired by both of them through their work or industry shall be governed by the rules of co-ownership. So, in contrast to Article 148, under the foregoing article, wages and salaries earned by either party during the cohabitation shall be owned by the parties in equal shares and will be divided equally between them, even if only one party earned the wages and the other did not contribute thereto. So, conformably, even if the disputed death benefits were earned by the deceased alone as a government officer, Article 147 creates a co-ownership in respect thereto, entitling Susan Nicdao to share one half thereof. As there is no allegation of bad faith in the present case, both parties of the first marriage are presumed to be in good faith. Thus, one half of the subject of death benefits under scrutiny shall go to the petitioner as her share in the property regime, and the other half pertaining to the deceased shall be passed by to his legal heirs, namely his children with Susan Nicdao. So the Supreme Court also reiterated that in construing Article 40 of the Family Code, they clarified that a prior and separate declaration of nullity of a marriage is an all-important condition precedent only for purposes of remarriage. That is, if a party who is previously married wishes to contract a second marriage, he or she has to obtain first a judicial decree declaring the first marriage void before he or she could contract said second marriage. Otherwise, the second marriage would be void. So the same applies even if the first marriage is patently void, because the parties are not free to determine for themselves the validity or invalidity of their marriage. So that's the case of Carino versus Carino. Just to reiterate the important things to take note for this case, Article 4, marriage license is an essential requirement of marriage, and absence of it would make the marriage void. But let's all remember that the invalidity of a marriage may be invoked only on basis of a final judgment declaring the marriage invalid, except as provided in Article 41. Article 40 also said that a prior declaration of nullity of marriage is important only for the purposes of remarriage. So this means that if a previously married individual wishes to contract a second marriage, then he or she has to first obtain a judicial decree, a final judgment that his first marriage was void. Otherwise, his second marriage would be void. So that's the case of Carino versus Carino. That's it for today's episode, guys. By the way, if you want to get a copy of the full text of the case, highlighting the important details I mentioned earlier, you may want to check this podcast description for the link. Thank you for listening and talk to you next time.